Dear learners, welcome back to the course on human rights, international, humanitarian and refugee law. In this section of the course, we are going to focus on the Indian Constitution and its affinity to human rights. The history of human rights in India goes back to ancient times, which continue to the medieval and modern times of the country. Human rights in ancient India were promoted by Indian political thinkers and philosophers. In ancient India, legal principles were founded on dharma, which aimed to promote the well-being of all beings and prevent harm among them, as evident in epics like Ramayana and Mahabharata. The Bhagavad Gita emphasizes righteousness as the core of dharma. The Upanishads regard dharma as the fundamental underpinning of the entire universe. The Vedas and Smritis advocate the concept of Vasudeva Kutumbakam, portraying the world as a unified family. All four Vedas underscore equality and dignity of every human. Buddha's teachings played a significant role in safeguarding human rights and promoting women's rights and equality. Not only religious efforts, but also political efforts were also made towards promotion of human rights. For example, King Ashoka effectively established a welfare state for his subjects, ensuring basic freedoms and rights. The belief and practice of human rights continued in the medieval India as well. The medieval period in India, though, was marked by invasions and difficulties, as this was the era of Muslim rule over India. Before the Mughal rule, there were existing rights related to society, politics, culture and religion. However, with the arrival of the Mughals, the concept of human rights faced challenges. Even then, kings like Akbar were a good example. In Akbar's reign from 1526 to 1605, significant emphasis was placed on social, religious and political rights. Akbar introduced a religious policy called Deen-e-Ilahi or divine religion, which aimed to promote secularism and religious tolerance. Moreover, religious movements like Bhakti and Sufi played a crucial role in advancing the history of human rights in India. In modern times, India faced colonial rule at the hands of the Britishers. During this period, the British government of India not only restricted the freedom of its people, but also built its foundation upon exploiting the masses, causing economic, political, cultural and spiritual harm to India. However, this oppression strengthened the idea of human rights, like self-determination and freedom in the minds of all Indians. After enduring colonial rule, every Indian firmly believed that the recognition, safeguarding and implementation of human rights were not only fundamental, but also essential to live a respectful life. That is why the concept of human rights under the Indian Constitution runs like a golden thread. The Constitution of India was adopted on November 26, 1949. According to Article 394 of the Constitution, the whole of the Constitution except Article 5, 6, 7, 8, 9, 60, 324, 366, 367, 380, 388, 392 and 393, which also came into force at once. However, they came into force on January 26, 1950, which is referred to as the day of the commencement of the Constitution. Let us discuss about the Motilal Nehru Committee. In 1925, the Indian National Congress finalized the draft of Commonwealth of India adopting a Declaration of Rights. The Madras session of the Congress held in the year 1927 demanded incorporation of a Declaration of Fundamental Rights in any future constitutional framework. A committee under Motilal Nehru was appointed by the National Congress to study the fundamental rights. It is interesting to note that the Constitution of the Republic of India enacted in 1950 incorporated 10 of the 19 rights enumerated in the Motilal Nehru Committee Report 1928. The rights emphasized by the Motilal Nehru Committee Report were personal liberty, inviolability of dwelling place and property, freedom of conscience and of profession and practice of religion, expression of opinion and the right to assemble peacefully without arms and to form associations, free elementary education, equality for all before the law and rights, right to the writ of habeas corpus, protection from punishment under ex post facto laws, non-discrimination against any person on grounds of religion, caste or creed in the matter of public employment, equality of right in the matter of access to and use of public roads, wells, etc., freedom of combination of association for the maintenance and implementation of labor and economic factors, right to keep and bear arms, equality of rights to man and women. However, the Simon Commission appointed by the British government in 1927 totally rejected the demands voiced by the Nehru Committee report. In 1930, the Congress Working Committee gave a clarion call for the attainment of Purna Swaraj. The Karachi session of the Congress in 1931 adopted a detailed program of fundamental rights. The drafting of the Karachi resolution has been credited to Pandit Jawaharlal Nehru. In March 1931, the Congress Convention held at Karachi adopted the resolution on economic and social changes and fundamental rights. It was a declaration of rights and a humanitarian and socialist manifesto. The document's provisions did in fact become the spiritual and in some cases the direct antecedents of the directive principles of state policy in the Constitution of India. The Government of India Act 1935 is a landmark act which further advanced the movement towards self-rule leading to the independence of India. This act, for the first time by the colonial administration, aimed at establishing the federal system of the Government of India, the most complicated document ever enacted by the British Parliament, running into 451 clauses and 15 schedules. The major features were All India Federation, provincial autonomy, diarchy at the centre and federal court. The framers of the Constitution perceived unity, social revolution and democracy as the three interdependent goals which had to be sought together and could not be pursued or achieved disjointly, which Granville Austin also agreed to. However, the Government of India Act 1935 was passed without any Bill of Rights, much to the disappointment of the Indian leaders. This Sapru report, published in 1945, vitiated by communal tensions and conflicts around this time, concerned itself mainly with the problems of minority fears which were overshadowing the political scene in India. By this time, it had become clear that India would achieve its independence in the near future and the minorities had to be reassured about their security. The Sapru report declared that the fundamental rights within the new constitution would have to include certain safeguards and minorities. The report stated that what the constitution demands and expects is perfect equality between one section of the community and another in the matter of political and civic rights, equality of liberty and security, in the enjoyment of the freedom of religious worship and the pursuit of the ordinary applications of life. Through the Independence Act of 1947, India attained independence on 15th August 1947 and the British colonial rule in India came to an end. The same act had also conferred power on the Constituent Assembly to frame a constitution for India. This act was the result of a prolonged struggle for political freedom, and the constitution of the Constituent Assembly as the precise mechanism and authority to draft the constitution for India was the precise course to follow for the new nation state for its political sovereignty. It was the Sapru Committee of 1945 that subsequently stressed the need for a written code of fundamental rights, and the Constituent Assembly raised a forceful demand for the inclusion of human rights in the Constitution. The Indian Constitution was framed by the Constituent Assembly of India, which met for the first time on 9th December 1946. The Constitution of India gave primary importance to human rights. To quote Guha, the demand for a declaration of fundamental rights arose from 4 factors: lack of civil liberty in India during the British rule, deplorable social conditions particularly affecting the untouchables and women, existence of different religious, linguistic and ethnic groups encouraged by Britishers, and exploitation of the tenants by the landlords. Although the first sitting of the Constituent Assembly took place on 9th December 1946, the provision for its constitution through the cabinet mission had already been made. Initially, it had 207 members, including 15 women. It was reckoned by the Constitution Drafting Committee that the inclusion of traditionally marginalized sections was to be of prime importance in order to ensure that their concerns were reflected in the Constitution. The committee consisted of several national leaders like Dr. Rajendra Prasad, Pandit Jawaharlal Nehru, Maulana Abdul Kalam Azad, Dr. B.R. Ambedkar and others as members, with Dr. Rajendra Prasad as its chairman. Once a federal constitution was decided upon, the major models were selected for study. The models fell mostly into 2 categories: the Constitution of the United States on the one hand, and the Constitution Acts passed by the British Parliament establishing federal constitutions for Canada, Australia and India, all of which had drawn mostly on the American experience. Various committees were constituted by the Constituent Assembly to deal with different aspects of the Constitution. The reports of these committees were considered by the Constituent Assembly, and it appointed a drafting committee under the chairmanship of Dr. B.R. Ambedkar, whose efforts had finally culminated in the adoption of the Constitution of India by the Constituent Assembly on 26 November 1949, and it came into force on 26 January 1950. The Constituent Assembly incorporated in the Constitution of India the substance of the right proclaimed and adopted by the General Assembly in the Universal Declaration of Human Rights. Further, on 10th December 1948, when the Constitution of India was in the making, the General Assembly proclaimed and adopted Universal Declaration of Human Rights at UN, which surely influenced the framing of India's constitution. Viewed from Indian standpoint, human rights have been synthesized, as it were, not as an integrated fabric by the preambular promises and various constitutional clauses of the Constitution of 1950. The Constitution of the Republic of India, which came into force on 26 January 1950, with 395 articles and 8 schedules, is one of the most elaborate fundamental laws ever adopted. The preamble to the Constitution declares India to be a sovereign, socialist, secular and democratic republic. The term democratic denotes that the government gets its authority from the will of the people. It gives a feeling that they are equal irrespective of the race, religion, language, sex and culture. The preamble to the Constitution pledges justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and fraternity assuring the dignity of the individual and the unity and integrity of the nation to all its citizens. As indicated by the preamble of the Indian Constitution, India is a sovereign, socialist, secular and democratic republic. The words socialist and secular and integrity were added after the 42nd Amendment of the Constitution. The preamble starts with the words, "We the people." This expression signifies a departure from the traditional view of the sovereign, that is, a departure from the concept of sovereign as some determinate person, and seems to affirm the social contract theory of the state. As in the case of the preamble of the United Nations, so also in case of the preamble of Indian Constitution, the expression "we the people" is neither incidental nor a mere embellishment. The expression is in fact concretized into many provisions in the Constitution so as to give it content and meaning. To like the idea of common freedoms under the Indian Constitution, it is relevant to take a look at the points and objects of the preamble, which are surely the points and objects of Indian Constitution as well. The preamble mirrors the high purposes and respectable goals of the designers of the Constitution. The expressions of the preamble reflect the expectations of the individuals. The ideas of the preamble lay down the basis for all human rights, such as right to education, equality, fraternity, etc. These are applied without any discrimination on the basis of race, religion, gender, etc. India was a signatory to the Universal Declaration of Human Rights 1948. A number of fundamental rights guaranteed to the individuals in Part 3 of the Indian Constitution are similar to the provision of the United Nations Universal Declaration of Human Rights. In Keshwanand Bharati versus State of Kerala, the Supreme Court observed, "The Universal Declaration of Human Rights may not be a legally binding instrument. However, it shows how India understood the nature of human rights at the time the Constitution was adopted." In the case of Jolly George Varghese versus Bank of Cochin, the point involved was whether a right incorporated in the Covenant on Civil and Political Rights, which is not recognized in the Indian Constitution, shall be available to the individuals in India or not. Justice Krishna Iyer reiterated dualism and asserted that the positive commitment of state parties ignites legislative action at home, but does not automatically make the covenant an enforceable part of the corpus juris in India. Thus, although the Supreme Court has stated that the Universal Declaration cannot create a binding set of rules, that even international treaties may at best inform judicial institutions and inspire legislative action. Constitutional interpretation in India has been strongly influenced by the Declaration of Human Rights. In the judgment given in the Chairman, Railway Board and others versus Mrs. Chandrima Das, the Supreme Court observed that the Declaration has the international recognition as the moral code of conduct, having been adopted by the General Assembly of the United Nations. The applicability of the Universal Declaration of Human Rights and principles thereof may have to be read, if need be, into the domestic jurisprudence. In a number of cases, the Declaration has been referred to in the decisions of the Supreme Court and state high courts. India ratified the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights on 27th March 1979. The optional protocol, though, to the International Covenant on Civil and Political Rights 1989 was not ratified by India. A very important act of India regarding the human rights status in the country is Human Rights Act 1993. This Act of 1993 in India represents a significant legislative step in strengthening the framework of human rights protection in the country. This Act was enacted in response to India's ratification of the International Covenant on Civil and Political Rights (ICCPR) and the International Covenant on Economic, Social and Cultural Rights (ICESCR), aligning domestic law with these international commitments. Key aspects of the Human Rights Act 1993 include definition of human rights. The Act defines human rights as those relating to life, liberty, equality and the dignity of the individual as guaranteed by the Indian Constitution and the international covenants. This definition acknowledges both constitutional and international dimensions of human rights. Establishment of human rights commissions. One of the Act's most significant provisions is the authorization for the establishment of National Human Rights Commission (NHRC) and State Human Rights Commissions. These commissions are tasked with the promotion and protection of human rights at the national and state levels respectively. Functions and powers of the commissions. The Act outlines the functions and powers of these commissions, which include inquiring into violations of human rights or negligence in the prevention of such violation by a public servant, reviewing factors that inhibit the enjoyment of human rights and recommending measures for their effective implementation. Composition of the commissions. The Act provides for the composition of these commissions, ensuring they are comprised of members with significant experience and knowledge in the field of human rights. Enforcement by human rights courts. Human rights as defined under the Act are enforceable by the courts in India, providing a legal mechanism to seek redress for violations. Overall, the trajectory of human rights in India reflects a gradual shift from a class or status-based approach to a more inclusive, legally enshrined set of rights, aligning with international norms and standards. As we could see throughout this lecture, that India's constitutional development has been closely conforming to the international standards of human rights. Well, that should be all for this lecture. We will meet soon with other such aspects of this course. Till then, take care and bye for now.